All right, so let's talk about the legal writing aspect. Of course, grammar plays into it, but um, remember that legal research and writing is going to refer to the ability to find, interpret, and apply legal authority that is done effectively so that you can persuade or inform, your reader. So this week we're going to be kind of shifting into more detailed writing. And I'm going to give you individual lectures for those particular assignments, but I kind of wanted to just take a minute to back up and kind of go over a few things. Just because honestly, I can't stress enough that, whether you're drafting a contract, a motion, or writing something, a memorandum, the clarity and precision that you use can actually determine an outcome. For example, if you have a poorly written brief with very unclear arguments, it can lead to a judge to dismiss your motion. And it's not because your argument was weak, it's because it was unclear. And that's why I can't stress this enough. So, learning how to draft these arguments is going to help you in terms of being as clear as possible, concise as possible, and using well supported arguments from case law and statutes and, legal principles. So let's say that you're doing a motion to suppress evidence. You would have to tell the court why certain evidence should be excluded. And you're going to have to do it based on either constitutional grounds or procedural violations. You can't just put that in there and expect the court to read, your mind. You have to be able to not only put it out there, but you have to make it good. You have to make it so that the judge is going to go, I agree with this. Okay. And that is something that is very important. This is about, our legal reasoning that we're giving. And again, we want the judge to side with us. So again, I just wanted to kind of go over some, let's just go over like the role of writing when it comes to advocacy. Okay. And again, I can't stress this enough that, advocacy is what you're doing when you're representing a client in your job. So, why is legal writing so important? Um, when it comes to litigation, it is the most important skill. And that's because judges and attorneys spend more time reading briefs than they do listening to oral arguments. And over 90% of cases are actually decided based on written motions before a trial ever occurs. When it comes to like appellate cases, did you know that fewer than 1% of them actually involve oral arguments? So most appeals are also decided on written submissions. So this well-written brief can persuade a judge before an oral argument like even begins. And when you have poor writing, which is unclear, it's unorganized, or it's unsupported by legal authority, or a combination of the above, again, it can weaken an otherwise very strong case. And that's because a weak legal argument can be strengthened by legal writing that's excellent, but a strong legal argument can actually be lost in bad writing. So, again, a trial court can rule against a party not because they have a weak case, but just because their brief failed to clearly lay out the legal argument. I hope that makes sense. So now let's talk about the differences between persuasive writing and objective writing in legal writing. So objective writing is going to present facts and legal issues neutrally. Okay, and this is often used in like legal memos. But persuasive legal writing is going to argue for a specific outcome. And this is what we're going to use in our trial and appellate briefs. Now, your objective writing, remember that it's going to be used in legal memos, advisory opinions, legal research, things like that. And it is going to present both sides of an argument neutrally, okay? And it's going to focus on legal precedent without actual advocacy. But persuasive legal writing is going to be used in the trial and appellate briefs, and it is going to take the clear position in favor of one party. And it's going to use rhetorical techniques, precedent, and logic in order to persuade a judge. So let's talk about an example. Let's say that you're writing a motion on behalf of a tenant, okay? Your persuasive argument is going to take a clear stance. For example, the defendant landlord was negligent by failing to remedy the mold issue, thereby violating OCGA 44-7-13, which imposes a duty on landlords to maintain habitable conditions. This is clearly showing that the tenant is not in the wrong, the landlord is. But let's look at objective writing. So this is where you might have an attorney who's asking you to research whether or not a person can sue a landlord specifically for mold exposure. So your objective response should summarize basically the relevant cases without taking an actual side. So I'm not going to give you the whole thing, but like it would say, like under Georgia law, a tenant may have grounds for a negligence claim against a landlord for failure to remedy mold conditions, provided that, and then you would list out whatever needs to be added from the actual law, cases, things like this. So this is saying the tenant may. And that is going to be objective because it's not clearly taken a position for one side or the other. So let's talk about a trial brief for just a moment, okay? Because again, we're going to start working on our trial brief this week, and then we'll start digging into an appellate brief. But a trial brief is a legal document that gets submitted to a court, and it's going to argue why a judge should rule in favor of a party on a motion before trial or during trial. And the key features of this trial brief is that it's going to focus on the specific facts of a case, okay? It is going to apply legal authority. So your statutes, your case law, and it's going to take those legal authority, statutes and case law, and it's going to apply it to those specific facts. So you're going to argue why the law supports the client's position. And it's going to request immediate relief from the court. So your job is to convince the trial judge to either grant or deny a motion. So, for example, like if you have a motion to suppress evidence in a criminal case, you would be arguing that this particular evidence was, illegally obtained and it should not be allowed at trial. So this would be where you're going in, you're asking for immediate relief, and you're having to convince them why they should throw it out. So the structure of a trial brief is going to basically look like, honestly, kind of like IRAC, okay? Again, it's going to have a statement of facts. So you're going to present the background of the case itself. You're going to give the procedural history, and this is going to explain what has happened in the case so far in court. You're going to have the argument, which is where you're going to present the legal reasoning. And remember that this is based on case law, statutes, legal precedents, things like that. And then you're going to have the conclusion. And this is where you're going to request a specific ruling from, the court itself. But again, we want to remain focused, okay? So again, we're applying the law to the specific facts of the case, okay? Period. Nothing more. We have to stay very, very focused. And that's why when you're even picking out background facts, you have to stay with the facts that are just necessary to what, is being put before the court. Now, even though we aren't doing the appellate brief yet, I'm going to go ahead and just kind of talk about it for a second, because this is going to be, again, the legal document that goes to an appellate court. and it is going to argue that the trial court's decision was legally incorrect. And so this is going to focus on legal errors, and they're legal errors that are made by the trial court. It is intended to identify and analyze these errors that occurred during trial. And they will use precedent and case law to argue for either the court to affirm the decision or to reverse the decision. But the job here is to persuade the appellate court that the trial court either correctly or incorrectly applied the law. This is not the time to introduce new evidence. It is only for legal analysis. Okay. So let's say that you have, a criminal defendant who is appealing a conviction, and maybe there was like improper jury instructions that were given. So your argument might be based on the fact that it violated their due process rights. Again, the jury instructions happened during the trial. The court would have allowed it. So this is what we're going to argue. We're going to structure it around this particular event. Now, the appellate brief structure is going to also be kind of similar to IRAC, and maybe even, I don't know, maybe kind of a little more so, but it's going to start with an issue statement. And again, this is going to clearly define the legal question. I know it says issue statement, but it's actually a question, okay? Then we have the standard of review. And this is going to define whatever appellate standard is being applied. Are we looking for a de novo, or is it an abuse of discretion, whatever, okay? Then we're going to have a statement of facts. And this is going to get presented in a way that supports the argument, which comes next. And so the argument is going to rely heavily on precedent, case law, statutory interpretation. And then we're going to have the conclusion. And this is where we're going to request the appellate court to either affirm or reverse the lower court's decision. And again, our focus here is going to be on legal reasoning or maybe misapplication of precedent by the trial court. We're going to be looking at the interpretation of law rather than any kind of factual disputes. Because again, remember, we're not introducing new evidence. We're not relitigating a case. Okay. So let's talk about ethical considerations in legal writing. Now, there are a few ethical considerations that we need to discuss. First is the duty of candor. Okay. And this is where lawyers have to present the law fairly and truthfully. Okay. And the model rule of professional conduct actually does things like prohibit, say, an attorney from knowingly making a false statement to the court. So if you have a lawyer who misquotes a case to make it seem like more favorable to their argument and it gets discovered, then it can result in sanctions or even disbarment because they owe a duty to the court to do the right thing. Now, we want to avoid misrepresentation, okay, and as part of the duty of candor, but we need to break this one down just a little bit more. Don't mischaracterize. And what this means is don't mischaracterize case holdings or statutory language. Let me give you an example. In Smith versus Georgia, the court held that all self-defense claims must be granted if the defendant claims they feared harm. Okay, let's say that this is what's being presented to the court, but it's wrong. And that's because in this case, maybe the actual ruling was that the court ruled that self-defense applies only when the defendant's belief of harm was reasonable and proportionate to the actual threat. Okay, so it would need to be reworded because this has been mischaracterized. So in Smith versus Georgia, the court held that self-defense applies when a defendant's belief of harm was objectively reasonable and the force used was proportionate to the threat faced. Period. It's much more detailed. It is correct, and it is not, skewing anything to one side or the other. Now let's talk about omitting adverse precedent, because you can omit it, but you can't do it without distinguishing it. Okay. And let me show you what that means. So let's say that you're citing, a State v. Miller, and it's because you're arguing a self-defense case, and the attorney, is using State v. Miller because the court found in favor of the defendant, but they failed to mention State v. Johnson, where the court ruled against a similar claim. So this is wrong. We would need to back up and have both. So State v. Miller supports the defendant's self-defense claim. However, in State v. Johnson, the court rejected self-defense due to the defendant's use of excessive force. The distinction in our case is that defendant's response was proportionate, unlike in Johnson, where the force used exceeded the perceived threat. So in this particular case, we are distinguishing it. So we're using both of them. We're saying, look, we should use State v. Miller. And I know that State v. Johnson is out there, but let me tell you why State v. Johnson doesn't apply. So it has that whole sentence about the distinction is, and it goes into the explanation. Now, let's talk about the proper use of persuasive techniques, but we have to break this one down a little bit more too. We need to use logical reasoning, and we are going to use this instead of using emotional appeals. Let me show you what that looks like. So if the court denies Mr. Carter's self-defense claim, it will be sending the message that innocent citizens must be victims of violence rather than defend themselves. Okay? This is an emotional appeal, and it's wrong. Okay? We want to use, under Georgia law, self-defense is justified when an individual reasonably believes force is necessary to prevent imminent harm. It even cites the law, OCGA, section 16-3-21. Given that Mr. Carter was physically grabbed before responding, his fear of harm was reasonable and his response was proportionate. So this is a logical argument. We are not trying to say, oh, well, innocent citizens are victims. And those are a lot of, trigger words. They're words that are going to evoke emotions out of people. And we don't want to do that. We want to stay on point and keep it grounded. Okay. Now, when it comes to applying analogies to favorable cases, we do this because it strengthens arguments. Let me show you. So our example is in State v. Brown, the court ruled that a defendant who used force after being physically assaulted had a valid self-defense claim. Just as in Brown, Mr. Carter responded to a physical altercation with a single defensive action demonstrating a proportionate response. So this right here would be an analogy of a strong would be an example of a strong analogy, and it strengthens the argument that we're using self-defense because we are showing that, they're being physically assaulted. And again, we are showing that Mr. Carter was also physically assaulted, and it was just a proportionate response. So this would be considered a good analogy. Now let's talk about the importance of proper citation and avoiding plagiarism. So improper citation can actually lead to ethical violations, but let me show you what it looks like. The Supreme Court has ruled that self-defense must be based on an objectively reasonable fear of harm. I mean, it looks okay, right? But it has no citation, so it'd be considered plagiarism. It's wrong. So instead, we want to use the Supreme Court held that self-defense requires an objectively reasonable fear of harm. And then we're going to cite Graham versus Connor, 490 U.S. 386, 1989. When it comes to plagiarism, judges are going to expect paralegals, attorneys, everybody to accurately cite legal authority. Most of them do use the Blue Book format. But again, that's going to be up to the individual courts to determine their own procedure. But let's talk about what this looks like. State v. James, 2015, held that all self-defense claims must be accepted if the defendant claims they were afraid. Okay. Now, the issue here, it does not have a full citation, right? But what if, okay, just what if it's wrong because no such case actually exists? That's a problem. We don't want to do that. Instead, we want to have something like courts have consistently held that self defense requires both subjective fear and an objective basis for that fear. And of course, we want to cite, whatever case it is. But in this case, I put State v. Adams, 322 Georgia 400 2020. Now, I know you heard me mention Mr. Carter earlier, and that's because he is the basis of our hypothetical case of State versus Alex Carter. And I'm going to make sure that I put this up on any assignments that deal with Mr. Carter. But the basic overview is that Alex Carter was charged with aggravated assault and reckless conduct after a bar fight. And then we have the victim, who is going to be Michael Reynolds, and he suffered a traumatic brain injury after being punched. Okay. So the key issues here, or the key issue here, rather, is that we have to determine, was this self-defense or was it excessive force? Now, I want you to note the term key issue. And that's because we're going to next talk about key legal questions, okay? And these key legal questions are going to help us develop the answer to our key issue, okay? For example, did Carter act in self-defense? Was the force used proportional? Should Carter's charges be reduced from aggravated assault to simple battery? Okay, that's the type of thing. So what you're going to do is you're going to be researching your Georgia self-defense laws. And we're going to find 2 relevant cases, and we're going to create an outline of the potential arguments. But please wait until you see the slides for the actual assignments themselves, because I do a little more detail on those that I just kind of want to make sure that everybody is on, the same page. And next, I'm going to give you the videos for the 2 assignments. Please let me know if you have any kind of questions. Again, do not do assignments based off of this. You will have the individual videos, but I just kind of wanted to give you an overview. If you, again, have any questions, let me know. Bye.